very concerned that the, well, it goes back some time. We have, I think it's something like 20-some denials for, no, it's 16, 28? It's 28? Yeah, 28. I couldn't remember the number. Yeah. Well, I would say it's not the government, because the other ministries are participating and are taking them on. I give credit to the Ministry of Environment, I think, in that piece. So it very much a ministry localized, essentially a refusal to recognize the fundamental process of the ABR. They're saying you know they're using the excuse that oh well, we review the provincial policy statements every 5 years, and because the ABR says that you don't have to accept a request for review if something's been reviewed within 5 years, we just use that as a general excuse. But of course, what the ABR says is you can't ask for a review if something has been reviewed in 5 years unless you have new and compelling information, and almost all these applications have that. In other words, they have a legitimate cause, and I don't feel it is legitimate for the ministry to reject all these things out of hand, just to sort of on a level field. Other ministries take up these reviews. They do them. They do a good job. Some of the ones that M&R has done have been, profound and has changed public policy in a positive way. So, for them, and add to that, in the case of Ministry of Municipal Affairs and Housing, I mean, we've seen them dead wrong on at least a couple of occasions, going back a few years now, but on the Oak Ridges Moraine, they came out and said that the existing planning policies of the province of Ontario would protect the Oak Ridges Moraine, and guess what? They had to reverse that 100% and then pass the Oak Ridges Marine Protection Act to stop the process and do something else and pass special legislation to protect that landform. So, given their track record, they should do more reviews. That's a really good point, because the Goulburn wetlands is at its essence, is a conflict between two pieces of legislation or government policy which seem to work at odds to each other. On the one hand, you have the provincial policy statement requirement to protect provincially significant wetlands. So M&R sets down what conditions and tests and analysis to determine if a particular wetland is provincially significant, and then under the planning legislation, we're supposed to protect that from development. At the same time, we have the Drainage Act. The Drainage Act is to make sure land is drained for agricultural purposes and water is taken off the land. And what's happened in this particular wetland, it's one hand is provincially significant, on the other hand, the municipality is saying, oh yes, we're going to clean out the drains, we have an obligation. And the threat is, if you clean out those drains and make them operate, which is legal, but you will drain potentially drain the wetland so it's no longer provincially significant, thus opening the land for development. Not the intention of either piece of legislation, but it's at the focus of a conflict there. And I think that makes it fortunately, there aren't too many of those cases out there, but that one's worth following, an interesting one. Once the wetland's gone, if the wetland no longer scores high enough on the values set out by the M&R, it's a little form you go through and value everything, and it's a numerical thing. And once your score falls below a certain value, it's no longer provincially significant. Oh, you don't get it. You don't get planning protection. Oh, guess what? So we're using if that happens, we've used an agricultural piece of legislation that's supposed to protect farmland, and a planning piece of legislation is supposed to protect wetlands, with the result that land is available for housing development. I think it's a very serious, it's clash between two, there's no way of resolving the two conflicting pieces of legislation. It could be, there could be an initiative, a policy initiative, doesn't even have to be legislation, I don't think, but a policy initiative by the government to straighten that out. Now, on the good thing, it doesn't happen very often. There aren't very many agricultural drains through provincially significant wetlands. But where it happens, there should be a mechanism to resolve this conflict, because they're contradictory. We got the same thing in the same report. We talk about the conflict between designating lands for parks or conservation reserves and staking mining claims, and there's an absence of a mechanism. Once a mining claim is staked, even if the government, they've told us that even if they really want for primary natural heritage conservation purposes to put those lands in protection or into a park or such things, they have no mechanism to get out of the mining claim. And that's one thing I asked them to correct. Well, you should have the mechanism. You should have the choice. Similarly, in the Ottawa area and the Goulburn wetland, there should be a mechanism that the option of protecting is there against agricultural training. The Richmond landfill, we're talking, you know, the history, an old landfill from, I believe, the 1950s that was built on and expanded, which was common in Ontario, that we sort of built on the existing landfills. But this one, so the site location was never, by any modern standards, never chosen well. And in fact, and we've looked into this, and in fact, it's arguably one of the worst sites in Ontario to ever locate landfill, but there is a very large landfill there. Let us acknowledge there's millions of tons of waste there. It's been properly deposited. It's almost full to its final contours, but it's in a very, very bad site. There's very little soil on that site. The limestone rock below it is fractured, which means it has all sorts of cracks and channels. It may even have what they call solution channels, karst formations in it. And the reason that's important is because if leachate gets down there, it runs just like water in a pipe. It doesn't filter through soil, doesn't interact with much bacteria, it doesn't get sort of naturally attenuated or treated to an extent. It can run large distances. It's also extremely hard to detect. If it's running in a crack here and we drill there, we get dry rock, we don't find the water, we don't find it. So it's difficult to monitor and extremely difficult to monitor. And we know there is leachate because the first phase of that landfill site was done without any liners. Several subsequent phases were done with a lining system that we do not consider adequate by today's standards. So, and those liners will fail and will break down. So it can get into a fractured limestone in an area that's hydrogeologically complex. So, and people do use the groundwater in the vicinity. This leachate can travel great distances and contaminate sites that well beyond expectations. But the key point for me is that looking at the geological, there are some other complexities that I won't go into, but suffice to say that it is extremely difficult, if not impossible, to monitor the site and to determine what's going to happen to this leachate, where it might go, just because of the geology. And because of that alone, I say no more waste. Fill to its final contour, to close it down, closure plan, finish it off. Yes, there'll be continuing problems. Yes, it'll have to be monitored. But if we seal it off now, we'll minimize the leachate going forward. Keeping it in operation for more years at this low rate just continues to exacerbate and make the problem complex. And we've already been through a very trying and complex review and attempt to expand the site, and it was found to be inadequate for technical reasons, sound technical reasons. So if the site is inadequate, if closure will minimize the impact, and if there's really no capacity there anyway, and the current filling rates are so low as to be not really servicing any great need, close it. Let's close the door on that bad chapter of landfill in Ontario.